Yes, hi everyone. Today we're talking about misrepresentation. And suppose that there is a seller who, under a trust of land, manages a trust, and in breach of that trust, he does not consult the beneficiaries, and he goes on to sell the land which they live in. Before he does that, though, um, before he does that, he lies to a prospective purchaser. That could be either a mortgagee, a purchaser of a leasehold, a purchaser of a freehold, that there's no overriding interest, which means there's no people living in the house. However, the purchaser goes on and makes his own investigations, and it turns out to be that there's a overriding interest. An overriding interest, which means there is a property right, that's a trust of land, which predated the time of the sale, and it was reasonably obvious at the time of the sale. However, despite not being discovered by the purchasers for the purposes of that example, so it binds him. And he has given money, has spent money, and in order to find out that he doesn't own that land, because the overriding interest, for those of you who don't know, it does not appear on the title register, and it's a bit of a sneaky interest in the sense that it needs to be discovered. And although most of the times it's obvious for it to be discovered, there are some times that it has not been discovered, and in that case the purchaser is going to potentially sue the seller for the misrepresentation. And the question is whether he's going to be able to sell the seller for misrepresentation, since he relied on his own investigations, his own advice. It is well-known rationale in law that when you rely on your own investigations, you can't just say that you were induced to enter the contract because you did not rely on the other person's, on the misrepresentor's misrepresentation. He's not going to be able then to sue for misrepresentation. However, if he didn't rely on his own investigations, then he's going to be able to sue him. Now, could potentially the seller, the trustee, the fraudulent trustee, could he exclude liability by stating that no matter what the purchaser does, he will have to rely on his own investigations? No, he can't do that. He can't do that when there is a fraudulent misrepresentation, but this will also depend on the facts of the case and whether the misrepresentation is fraudulent or not. He can impose an obligation on the purchaser of mandatorily seeking and relying on his own investigations. However, if the purchaser relies on his own investigations, then the exclusion clause is useless, because he will have relied on his own investigations, and then the case of Atwoods versus Moore is going to apply, and he will not be able to claim damages for misrepresentation. Now, if there were two trustees or trust corporation, and the purchaser had paid the money over to those two trustees, there would have been an overreaching of the overriding interest. So he wouldn't have to depend on whether an overriding interest could arise, because it would have been overreached by that act. And of course it was an overreaching because he wouldn't have consulted the beneficiaries before selling the land. They would have been able to sue him for breach of trust and claim damages. However, they would not have been able to claim the right to the land, the right to the title back, and they would have been legally evicted from the land and not have a right to occupy and possess the land. thank you for watching. This video is merely informational and should not be taken as advice of any sort. See you on my next video, and please subscribe to my channel for more videos like that.